Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Hello and welcome to a special interview for The Wire. The Lok Sabha today started discussing the Waqf Bill, and it's expected that the Rajya Sabha will debate the bill tomorrow. It's clearly the most important item on the present political agenda. So today we ask, what is the Islamic rationale of Waqf? Is this an area where Parliament should legislate? What are the provisions of the new bill that are welcome? What are the provisions that are objectionable? And are there reforms that have not been included? My guest today is one of India's foremost academic lawyers, the Vice-Chancellor of Chanakya National Law University, Faizan Mustafa. Professor Mustafa, let me start by asking you to explain to those who aren't sure what a waqf is, how you would explain it. What is the Islamic rationale, and is it still valid today in the 21st century?
Thank you, Karan, for having me. Waqf is the most explicit expression of philanthropy in Islam. The newly established Islamic State did not have means, and therefore it encouraged people to do the social welfare. And therefore it asked people that out of their wealth, they should voluntarily come forward and do charity. The English law of trust also borrowed from the law of Waqf. Now, word Waqf, JPC is right in its report, is not there in Quran. But as many as 28 verses are there, which mandate Muslims to do something for the poorer section of their population. For instance, I am reminded of chapter 26, verse 19, and in your wealth, the beggar and the deprived had due share. So the whole idea of zakat, that 2.5% you pay annually on the day of Eid, we recently had Eid 2 days ago. Before you move for prayer, you have sadaqah-e-fitr, which is another type of charity. And then waqf is a kind of a charity where you create a kind of a trust, which is not exactly the trust because you cannot retain any benefit for yourself. The property will get vested in God, and that's why those who say that Waqf Board owns that many properties, Waqf Board is not owning any property. So the whole idea is of doing charity for the poorer sections of population. In India, the first Waqf was created in 1206 by Mu'izz-ud-Din Ghori in Multan for the maintenance of a mosque. Now today, government does take number of measures of social welfare, yet the idea of a waqf has a relevance because who will maintain mosque? No state in any country in the world, if it is a secular state, can be given the duty to maintain mosque and maintain burial grounds and maintain madrasas. State should not invest public money on that. And therefore, to maintain religious places, idea of a waqf remains relevant. Most of the mosques in India and burial grounds are maintained.
That is a very important answer you've given. You've indicated that although the word waqf doesn't appear in the Quran, nonetheless, the concept of waqf, the concept of charity does have Quranic sanction and support.
Correct. Because Quran is not a book of law. It is a book of ideas. It is a book of stories of earlier civilizations. It talks of things in a general and abstract way. So that concept is very much there, that you don't out of your greed consume everything. In your wealth, there is a share for the deprived sections of population.
Now, as an academic lawyer, do you have any problem with Parliament enacting a Waqf law which will clearly, therefore, affect and impinge upon the personal law of Muslims? I will point out to the audience, this is not the first time a Waqf law has been legislated in India. I believe the last occasion was 1995. But that said and done, given that it impinges upon Muslim personal law, do you, as a legal academic, have any qualms or any doubts or reservations about Parliament enacting in this area?
Some opposition leaders and some Muslim fanatics have also questioned Parliament's jurisdiction to enact Waqf law. But as a student of constitutional law, I have simply no doubt in my mind that Waqf is very much covered by the religious and charitable institutions, which is mentioned in the concurrent list, and both Parliament and the state assemblies have a power to make law on this subject. Of course, if there is a conflict between the central law and a state law, the central law will apply. Waqf Karan is the most regulated religious property. You don't have any central law in respect of Hindu religious properties. But for Muslims, you have a law from 1954. Then it was amended number of times. Last time in 2013, you got a comprehensive new law in 1995. So Parliament's power to make law on Waqf or amend the Waqf Amendment Bill is beyond question. I had also written and said that this is a myth that the entire Muslim personal law is uncodified. And it is also a myth that entire Hindu personal law is codified. There are subjects and areas where even Hindu law, in spite of Hindu code bill, still remains uncodified. Part of Muslim personal law has been codified, like the Waqf Act, like the dissolution of Muslim Marriage Act giving Muslim women right to dissolve their marriage, a 1939 law, or like the 86 law, or the recent triple talaq law. So there are a number of legislative interventions even in respect of Muslim law. The question is that any law which Parliament passes is tested generally on two tests. One, whether it has a jurisdiction. Of course, on Waqf, Parliament has a jurisdiction. Therefore, the only touchstone on which this law can be tested, is it violative of any fundamental right, including right to equality, which includes right against arbitrariness. And what is right against arbitrariness? You cannot single out one particular group for a special treatment when other groups are similarly circumstanced. Likes are to be treated alike. If you are passing one kind of law for Muslim religious properties, you need to have identical laws for other religious properties as well.
But as you pointed out, we do have a law for Muslim religious properties. It is the Waqf Bill and the Waqf Act of 1995. Correct. But we do not have similar identical laws with the same rights and limitations for other religious properties.
We don't have a central law, but we have law in Karnataka, we have a law in Tamil Nadu, we have a law in Andhra Pradesh and Telangana, in Kerala, in Bihar. Number of states have enacted state laws on Hindu religious properties. You have a Gurdwara Prabandhak Committee Act for 6. What I am trying to say, in terms of regulation, to say that Muslim waqfs are having lot of freedom and other religious communities and religious properties are not having that kind of autonomy, it is not factually correct.
Okay, let's then, against that background, come to the present bill being discussed in the Lok Sabha today, and it will be, I believe, discussed and debated in the Rajya Sabha tomorrow. You deposed in front of the Joint Parliamentary Committee. I believe you spoke for 5 hours, longer than any other person. First, what are the provisions of the new bill that you as a legal academic welcome?
Karan, I can't divulge the details of deliberations in the Joint Parliamentary Committee meeting because there is a parliamentary privileges and I am bound by that confidentiality. But as an academic, I can tell you that there are a number of provisions in the bill with some reservations and here and there, and with some modifications and improvements here and there, which to me look fine. For instance, the whole question of that the chief executive officer of the Waqf board will be an officer of the level of a joint secretary. Currently, he is a lower officer of a deputy secretary. I think it is a welcome change. Similarly, Section 17 says that any Waqf which you create now must be notarized. Now, this is an improvement. So, oral Waqf will no more be allowed. From now on, Waqf has to be properly in a written document and you have to be an owner, even though this was a law earlier also, but it is now specifically stated, which I welcome. Where it misses, it says notarized. It does not say notarized and registered, because under the Registration Act, every document which is notarized need not be registered. Similarly, for instance, for the Waqf Tribunal, currently it says it will be headed by a civil judge, which in the judicial hierarchy is at a lower level. The new bill, which the Lok Sabha right now is going to debate in Section 83, says district judge will now head the tribunal, and I think this provision is to be welcomed. Similarly, now it says that the tribunal will give its decision in 6 months. So there will be more speedier disposal of cases. In terms of mutawalli, it says that a mutawalli who is a manager who on ground manages Waqf under Section 64, he can be removed if he fails to maintain accounts for 1 year. Diversity also, inclusion of women, inclusion of non-Muslims, even though that's a separate subject, is also one of the positive feature of this bill. I don't take digitization such a big thing because digitization already started in 2010. 42% of Waqf properties of 32 boards have already been digitized. Of course, the bill says that there will be a portal and this and that, but to say that this work can be completed in a year's time, I think is not right. It will take another 5 to 7 years when this digitization thing can be done.
Let me ask you, Professor Mustafa, the opposite of the last question. Clearly, there are 4 or 5 areas of the new bill that you welcome, that you think are positive. What about the opposite? What are the provisions that you are concerned about? What are the provisions that perhaps you even oppose?
What I will oppose, I'll tell first. It is not about the right of Muslims. It is about the right of non-Muslims. Now, the bill is putting the whole concept of ownership upside down. And that is the weakest part of this bill. Any non-Muslim under the current law can also create a Waqf. Of course, this provision was not there in the 1954. It was not there in 1995. It was included in 2013. But you have a history of non-Muslims creating Waqfs. So Hindu zamidars, Hindu nawabs used to, create Waqf, and then Waqf will establish mosque. So there are cases from Madras High Court, 1930 case, Lahore High Court, 1940 case, even a Nagpur High Court, 1956 case, where they upheld the right of a non-Muslim to create a Waqf. How can through any law, you say, I am the owner of the property, and with that property, I want to make a mosque, or I want to provide for a graveyard of people who are living in X locality. You say, since I am not a Muslim, I cannot create a Waqf. I think this violates the fundamental principle of right to ownership of a property. Just because I am a non-Muslim, I can't create a Waqf defies any logic. I think this is a provision which should not be there in this.
And just to clarify, earlier, both in 54 and 95, non-Muslims could create a Waqf if they choose to and wanted to. Now they can't.
In the Act, it was not written, but traditionally they were doing. This became an explicit provision in 2013. What I am saying that you have cases of pre-independence era where the right of a non-Muslim to create a Waqf was acknowledged and accepted by the British courts. The whole point is he is the owner of a property. The right to ownership includes right to destroy property, right to gift away property,
And
right
now
to do
you're
whatever
saying,
you want to do with your property.
and now you're saying the new bill of 2025 explicitly rules out the possibility of a non-Muslim creating a waqf.
Yes. And then interestingly, it says that if you convert, only after 5 years you can make a waqf. So if somebody even becomes a Muslim, first of all, Karan, even though the BJP states have what is said to be the anti-conversion laws, but none of these laws prohibit voluntary conversion. If you look at International Human Rights Covenant, International Covenant on Civil and Political Rights, or the United Nations instruments, it is specifically mentioned that freedom of religion includes right to convert. In India, we have not included that. That's fine. But voluntary conversion is very much constitutional. So somebody voluntarily converts to Islam. You still say he has to wait for 5 years before he can create a waqf. How can you make this classification that somebody will become a more Muslim after 5 years than when he converted to Islam? The moment somebody converted to Islam, entire Muslim law becomes applicable on him.
Absolutely. But in the meantime, this is an infringement on the right of the property owner to do with his property or her property what he wants. Suddenly,
Absolutely.
if
That's
he
why I'm
or
saying
she
even if
wants
he's
to create a waqf,
non-Muslim, he
they
should be
can't.
able to create it. Yeah, that's right.
Are there other provisions of this bill that you have concerns or objections to?
You see, look at the very title of this. Why are we passing a law? Any law we are passing. I am not a politician and I am not a member of any clergy and I don't represent any Muslim organization. But to any law, whichever law is passed, my first question will be why you are passing this law, particularly when this law has been recently amended. 2013, you had the last amendment. 1995, you had a comprehensive amendment. 1954, you came up with a law immediately after we became a republic. So what is the need? If the stated object of the bill is to improve the efficiency, administration, management, transparency, etc., of Waqf, then how can you achieve these laudable goals when you are weakening the Waqf board, when you are weakening the Waqf tribunal? What is a Waqf board? Waqf board is not a private body of Muslim mullahs. It is not a private body of Muslims. It's a statutory authority. It is a state within the meaning of Article 12. There can be a writ against a Waqf board. Most of the nominees of the Waqf board are nominated by the government. Government already has a tight control over Waqf board. It can give them directions under the current section 97. Under current section 99, it can supersede a Waqf board. Number of Waqf boards have been superseded by various state governments. Now we are weakening its powers. And we are saying simultaneously that it will improve its regulation because Waqf board, how it works, there are hundreds and thousands of Waqfs in a state. Waqf board is the apex body in that state which looks after the work of a managers of Waqf who are called mutawallis. The real corruption takes place at the level of mutawallis. Now Waqf board controls them, asks them that you give your accounts. The Waqf board's own accounts are audited by the CAG. Then you are reducing their financial powers as well. Currently, any Waqf is supposed to give 7% of their income to the Waqf board. Now you are saying they will give only 5%. So their financial powers are curtailed. Their administrative and managerial powers are curtailed. And we are saying it will improve the efficiency. If somebody encroaches a Waqf property, that punishment has also been reduced. And we are saying it will improve efficiency. So two things cannot be argued at one and same time.
This is clearly contradictory.
It is contradictory.
Is there a third measure that you're concerned and you have objections to?
Karan, we live in an age of specialization. I am not good to teach AI law. I may teach constitutional law, but for artificial intelligence, I need another expert. Now, who are survey commissioners? Under the current law, they are the public servants appointed by the government under the control of the government. They have been given under the current law the power of a civil court to call for evidence. When a survey commissioner will do a survey, they will look at the rent paid, they will look at all the documents of Waqf, they will look at the khasra, khatoni, taxes paid by them. Then the survey commissioner will make a recommendation to the Waqf board, which I told you is a government body. It is a statutory body, just like any statutory university like Delhi University. And then the Waqf board will make a recommendation to the state government. State government will publish in the official state gazette, in the Raj Patra. Then only a property will become a Waqf property. Now, if from a specialist officer called survey commissioner, you take away powers and give this power to the district magistrate, who is already overburdened. Number of administrative reform commissions have already said that the district magistrate is already having too much of a work. Then, of course, the work will suffer. So that is another area where I am concerned. And similarly, this Waqf by user thing, again, forget about Muslim law. It is a concept of law of property. I have a land in front of your land. Now, all the time you are using my land. I come and go, morning, evening, I don't object. Over a long period of time, you can claim my land by virtue of user. And we are going against the Babri Masjid judgment, Karan, in paragraph 1134. In the Babri Masjid judgment, Supreme Court has said Waqf by user is a principle of our jurisprudence. Over 20 pages, 5 judges of Supreme Court in Babri Masjid have written about Waqf by user. And still Waqf by user we are abolishing. It is not a right thing to do because it is again putting the law of property and ownership and possession upside down.
Now, Professor Mustafa, today's newspapers, in particular, I'm referring to the Hindu and the Hindustan Times, suggests that the Waqf by user clause has been retained. That's one area where the original bill of August 2024 differs from the bill that is tabled in the House today. Secondly, all existing Waqf properties will be honored and retained unless they are disputed or deemed to be government property. And thirdly, the power to determine whether a Waqf property is government property, which was originally conferred by the August 2024 version on a collector, will now be conferred on a more senior officer. If these newspaper reports in the Hindu and the Hindustan Times are correct, how significant are these amendments and changes?
They are correct and they are important. One, you see, Waqf law is not a retrospective law. Even if you are abolishing Waqf, you say it or you don't say it. Even if they don't explicitly say it. A property by me was vested in somebody 50 years ago. That property cannot be unvested now because the ownership stands transferred. We are in a law of property. Many Waqfs are 500 years old, 800 years old. If this law is prospective, only from today you can say no new Waqf by user can be created. And this should pacify concerns of many Muslims, particularly in respect of graveyards and in respect of mosques. Ideally, their law should say that there will be a presumption in respect of graveyards and mosques that they are Waqf properties, even if they do not have old documents. Because many old temples may also not have documents. So let's not go into the documents. We have seen when we insisted on documents how in CAA, 19 lakh people in Assam could not prove that they are citizens of India. So documentation started much later. In any case, in India, the documentation is not good. Even government many a times, does not have proper documents. So this is not that important. What is important that because there was a criticism, that a district magistrate is a direct executive official of the government. In many Waqf encroachment, it is the government which has encroached, and that person decides whether it is a Waqf property or not a Waqf property. It violates the principle of a natural justice that you are a judge in your own cause. Therefore, they have now, JPC has recommended, let it not be the district magistrate, but such disputes about government encroachment of Waqf properties will be decided by a designated officer who will be probably commissioner or not commissioner, because DM is also called deputy commissioner in some states. So that's a welcome change. But ideally, ownership dispute should be left to either a judicial forum or a quasi-judicial forum. And therefore, it is best that such disputes are decided by the tribunal. All members of the tribunal are appointed by the government. Government has accepted one suggestion. In the bill, they had said that there will be 2 members. And the third member under the existing law was supposed to be one who is learned in Muslim law, because Waqf is a Muslim law concept, which they had dropped. Now they have agreed to bring back that third member. So that's a welcome change.
So you're saying to me that the changes that are mentioned in the Hindu and the Hindustan Times, which you believe are the changes that have been accepted by the government, I have to tell the audience that we're only relying on newspaper reports to that effect, but these changes you believe are welcome changes.
They are welcome changes, and they were recommended by the JPC itself.
And as you say, this bill, from your understanding of it, does not apply retrospectively. So concerns that it would apply retrospectively are mistaken concerns. It applies prospectively only.
Of course.
Okay. From what I can tell, one clause that hasn't been altered is that non-Muslims will now be appointed to Waqf boards. I believe that also includes women. It also includes members of the OBC. How do you view that? If I understood one of your earlier answers correctly, you approve of the inclusion of women. Do you also approve of the inclusion of OBCs and non-Muslims?
As a student of law and somebody who has been doing administration, I believe diversity of the society should be reflected in all institutions. So on the principle of diversity, if more women are there, or if non-Muslims are there, or OBCs are there, I welcome this change. The problem is legal. And what is that problem? Article 26, Karan, gives a fundamental right to a religious denomination or any section thereof to own and manage their religious properties. Now, if this is a right of a Muslim to manage their religious properties, how can we give this right to non-Muslims? So there is a legal question and legal angle which worries me, how the court is going to look at this provision.
Do you think that this is the grounds on which a court could overturn this provision?
It may, because this kind of a provision you are not having in the Hindu religious properties laws in number of states. You will be surprised that even though Article 25 gives the definition of Hindu, which includes Sikhs, Jains, and Buddhists, but in number of Hindu religious property laws and charitable institutions and endowments laws, a Buddhist or a Sikh or a Jain cannot be the member of the temple board. Similarly, are we going to make similar kind of provision for OBCs there? About women, the existing law had not put any upper limit. The 2024 bill was a compromise in the sense it said maximum of 2 women you can have. Now JPC has removed that provision and they had restored the original provision. So any number of women can be there. So women who are coming in the ex officio positions will not be counted under this women head.
But you're making a very important point. Laws that exist in states to regulate Hindu religious property explicitly exclude non-Muslims. Here we are deliberately and explicitly including non-Muslims, and that is, to look at it prima facie, unfair and unequal.
That's how I am worried if an argument is made that this classification is arbitrary, it is based on religion, you cannot make a law only on the basis of religion, then court.
Then the court can. We've lost you, sir. Can you finish your sentence? You broke up. Then the court can.
You see, if you have a law for one religious community and you have another law on the same subject for other religious communities, it may be hit by Article 15, which says state shall not discriminate only on grounds of religion, race, caste, sex, or place of birth. And there may be some judges who may like to strike it down on this ground.
Finally, Professor Mustafa, let me ask you a more academic question, because I am talking to one of the country's foremost legal academics. I believe you hold the view that the Waqf Bill is a negation of the constitutional mandate for a uniform civil code and even a negation of the government's policy of one nation, one law. Do you hold that view? And very briefly, why is it a negation?
You see, as someone who teaches constitutional law, I have been writing for ages that the country has to one day have a uniform civil code. My suggestion has been that since this subject is so controversial and may polarize our society, move in phases and therefore get a uniform civil code in a piecemeal manner. You want to reform religious property law. In my opinion, this was a golden opportunity to take first positive step at the central level in the direction of a uniform civil code. A party which in states in the election manifesto and after the election, like in Uttarakhand, they had come up with a UCC. In Gujarat,
we've lost you again, sir.
So now they had an opportunity to bring a central law for all religious communities on the question of religious and charitable properties, and it would have been appreciated by one and all. Similarly, the stated public policy goal of the government is one nation, one law. If that is a goal, religious property is one subject, how can you have multiple laws in this? This bill is going in the reverse direction. It is going in the direction of legal pluralism. If this is so, the government should say that we have discarded the principle of one nation, one law. Otherwise, they should come up with one identical law on religious and charitable properties and endowments for each and every religious community in the country.
What you're saying, and I'll quickly sum it up because 2-3 times during your wonderful answer, we lost the connection. But what you're saying is this was an opportunity to start implementing the Uniform Civil Code step by step, and they should have come up with a central law for all religious properties, not just for Muslim religious properties. That would have been the first necessary step towards a uniform civil code, and it also would have been a way of implementing one nation, one law. But now you have a very different situation, which you call legal pluralism. You have a different law for Muslims, a different law for Hindu property, a different law presumably for Catholic and Christian property, and that makes a nonsense of the one nation, one law claim.
Correct, because that means you are saying you will have multiple laws. So the whole argument and debate of uniform civil code has got weakened by this.
Finally, my last question, Professor Mustafa, what is your message to Muslim institutions contesting the passage of this bill? What would be your message to them?
You see, as a student of constitutional law, first of all, they must accept that Parliament has a right to pass a law. In a democracy, a constitutional democracy, if you are unhappy about a provision of law, your only remedy is judicial review. You go to the court. Court will determine the constitutionality of that law. Of course, you will remember I had said on your show that this major constitutional matter will not be decided in that many years. So even if the Waqf Amendment Bill is challenged, Supreme Court would be unlikely to pronounce a judgment in the near future. And therefore, this will become a law. This will be implemented. Therefore, benefit out of the good provisions of this law, and try to improve internal management. If there has been corruption at the level of mutawallis who have been Muslims, if there has been encroachment of graveyards by Muslims, by members of the Waqf board, they have to blame themselves. Of course, I am not saying that there is no corruption elsewhere. You have a corruption in government. You even get cases of alleged corruption even from judiciary. So corruption has been normalized, so to say. But had the Waqf management been efficient, at least it would not have given an opportunity for others to say that we are bringing law to make it more efficient.
And what you're saying is accept the good bits, contest the ones you don't like in court.
That's the option Constitution gives you. If you don't like a law, challenge it in a court of law.
Professor Mustafa, thank you very much for your insights into the Waqf Bill. Thank you very much for explaining it in such simple, cogent, easy to understand terms.
Thank you very much for your very, very generous comments.
Take care. Stay safe.
Thank you.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch The Interview. Your viewership means an awful lot to me.